Hello，大家好，欢迎来到皮尔论道的 Piers Channel， 我是 Piers。今天呢，我们会做一期这个新闻听力训练。那么这次我们会采取跟以前不太一样的方式。因为这一则新闻呢比较长大概有30多分钟，而且呢它的连贯性还是蛮重要的，所以呢我就想在这一期主要是让大家就是听看这一则新闻，然后呢在后面我会给大家出一些题目算是测试一下大家的听力水平，还有是讨论一下这一次的这个政治事件。那么这个新闻的这个title 是这个关于这个华为孟晚舟事件的最新进展加拿大的政界还有司法界一些重量级的人物联署要求政府介入提早去结束这个引渡案还有释放这个孟晚舟。好，那么开始之前呢，还是再提醒一下大家因为之前我们有做过几期关于这个投资方面的专题包括股票、基金还有期权这些专业的这个投资方面的英语的这个节目，大家如果是错过有兴趣的话，可以点击右上角的这个连接去看一看。那么喜欢我们这个频道的朋友别忘了点击右下角的这个订阅键订阅 subscribe 我们的频道，然后点赞分享还有开启下一期节目提醒的小铃铛。好，那我们开始吧。好，那么再确定跟大家重申一下这一则新闻的 title 这个标题呢是 Should the federal government release Huawei executive Meng Wanzhou？ 好，那大家可以先听一听。
We begin tonight, though, with mounting pressure on the federal government to bring Michael Kovrig and Michael Spavor home. Last week, China formally charged them with spying after spending more than 550 days in detention. This all, of course, widely considered retaliation for Canada's arrest of Meng Wanzhou on a U.S. warrant. China has been demanding the Huawei executive's release, but this government says it will not interfere in the extradition case that is currently before the courts. Could it, though? And separately, should it? Alan Rock was the Minister of Justice and Attorney General from 1993 to 1997. He's now a law professor at the University of Ottawa, joins us from that city. Louise Arbour was a Supreme Court Justice from 1999 to 2004. She's also a former president and CEO of the International Crisis Group, which is where Mr. Kovrig was working before he was detained. She joins us from Quebec. Hello to both of you. Great pleasure to have you with us.
Good afternoon.
No.
Mr. Rock, I'll begin with you, and I want to start on that separate question, we'll start on the can and then go to the should. On the question of whether or not the government can intervene, the minister has said, the Minister of Justice, for example, once this all plays out, at the end, once a verdict is rendered, at that point it is my decision to sign off or to intervene. The argument put forth in the legal opinion that my understanding is you agree with is that there is an opportunity before that. Can you explain to our viewers what that opportunity is from your vantage point?
Yes, one of the things that troubled Louise and I when we looked at this case was the position the government was taking all along, that it had really no option but to allow the extradition proceeding to play out in front of the judge. The judicial phase of the proceeding had to go on as it might without any interference by government. It would be improper to intervene. The Prime Minister and others kept talking about the integrity of the courts and their independence. But when we looked again at the Extradition Act, it became clear that the Minister of Justice has every legal right to intervene at any stage of the proceeding up until the end of the judicial phase to terminate it. The section in the Act is quite clear. There are no conditions or qualifications. And so I think the threshold question here is the one you've put, Vashi, which is, can the government do something? We say it certainly can. It has the legal authority, always respecting the rule of law and the independence of the courts, to intervene now and put a stop to this extradition proceeding and, of course, we go on to say that it should. But that's the threshold question.
So Ms. Arbour, let me move over to the should part of this. You know what the government has said so far. It would set a precedent in which China could consider hostage diplomacy something that works for it, right? That a precedent would be set that if we were to sort of acquiesce to their demands and get involved and release Meng Wanzhou, that in return, they would consider this a tactic to try and secure a desirable outcome in the future. What is the case, Ms. Arbour, for actually intervening prior to the outcome of this?
Well, let me say at the outset that since the government has taken the position that it cannot do anything, as Alan has just explained, a wrong position in my view, we haven't had an intelligent public conversation about whether the government should actually take the steps to end the extradition process and thereby secure the release of these two Canadians. So it's highly unfortunate that a question of great public interest and importance has not been debated because the government has put a bar to this kind of debate by saying, well, there's nothing we could do about it, it's before the court. So I really think it's critical that we stress that point. And on that, in my view, the law is absolutely clear. This is not a question of interference with the judiciary and disrespectful of judicial independence. An extradition process is overwhelmingly an executive, political type process in which there's a small judicial part that the minister may interrupt at his own discretion at any time, in which case the judge is obligated to stop the proceedings. This is expressed formally as such in the Act. Now, whether the government should, let me just put it this way. First of all, when you start invoking bad precedent, it's a very good way of ducking, not addressing the issue in this case. This is a very unusual case, a very special case. And so it doesn't create a precedent for anything. I think it has to be examined on its merit. Even before the two Canadians were illegally arrested and are now being prosecuted in China, there should have been a very serious debate about whether it was in Canada's interest to proceed with this extradition request. This extradition request is based on the enforcement by the United States of its unilateral sanctions against Iran to try to force Iran to renegotiate a nuclear deal. These are not United Nations sanctions, they're US sanctions. Canada doesn't agree in terms of foreign policy with this strategy. Canada supported the original Iranian deal and didn't feel it was appropriate to have it renegotiated under threats of sanctions. Furthermore, these proceedings are conveniently addressed against a commercial competitor of some US interest, Huawei. So there were a lot of good reasons to look at this case with suspicion, and particularly when it would have been crystal clear to anybody that it would put Canada between a rock and a hard place, because China would oppose very strenuously and probably with more than robust, actually unconscionable means this situation. Add to that the presence of the situation of the two Michaels. It seems to me the case becomes quite overwhelming that Canada should have extricated itself from these proceedings a long time ago, and not having done so should do it now.
Mr. Rock, on the point that Ms. Arbour makes about extricating itself a while ago, maybe at the start of this process, a BC judge ruled that dual criminality does apply here, right? There was an opportunity for the courts to say, actually, you know, you shouldn't have complied with what the U.S. said because those sanctions weren't in existence here, and that's the argument that Ms. Meng's lawyer made, and the judge ruled against that.
Yes. Well, our point, Dashi, is not that there's a legal technicality on which this should be dismissed. Our point is, when you stand back and look at this entire panorama, the arrest of Madame Meng, the taking of two Canadian hostages, the coming of the pandemic, the extensive delays in the judicial proceedings, the risk to the health and indeed the lives of the Canadian hostages, the motivation of the American president, who cynically said he might withdraw the request if he has a good deal with China on trade. If you look at all the circumstances, there's a compelling number of reasons for us to stop this. But I'd like to come back, if I could, to the threshold question, because none of this gets anywhere unless we make the point and have the public and eventually the government accept the point that the minister has the authority to properly do this and can do it right now. Right now, the government's keeping us at arm's length and saying we can't talk about it, we can't intervene. I think this might be shades of SNC-Lavalin backwards. They were concerned about getting into that controversy that afflicted the government last year over SNC. This is a very different case, as Brian Greenspan explains in his opinion. So that threshold question is the most important at this stage. Can the minister do it? We say that it's clear that he can. And we haven't had a response from the Department of Justice because we provided a copy of the opinion to them over a month ago, to the minister. No response, no explanation as to why they say they cannot. I think it would be useful if they did respond, if they told us what their reasoning is. Let's have a discussion of that. And once we get over that, can the minister, then as you say, we go on to the question, should the minister? And there I think honest minds can differ, but Louise and I believe there are compelling reasons why indeed the minister should.
Ms. Arbour, and I should mention that we invited Minister Lametti to appear on the show to respond to this today, and he declined our request. But we do have another Minister of the Crown coming up, and I will ask about why they haven't responded to that legal opinion, which I believe was transferred to the federal government on May 22nd. Ms. Arbour, taking a step back, and I understand that I can't begin to understand the legal arguments to the degree that both of you do, nor the people who are involved in all of this. But I do sort of sit back and see the political discussion and the political blowback that the government would almost inflict on itself if they talked about intervening in this case. And I know that Mr. Rock just laid out, shades of SNC and things like that. But I do see from the government's perspective, if the Prime Minister got up there and after saying that this is the country of rule for the rule of law, said actually maybe we could intervene. There would be a ton of blowback for that, and they would be criticized very resoundingly for the exact thing that they were criticized for during SNC. Do you have any, empathy for that position?
This is entirely incorrect. First of all, the expression interfere is entirely inappropriate. This is not a question of interfering. You don't have to be a lawyer even to read Section 23.3 of the Extradition Act that says crystal clear, the Minister of Justice may at any time put an end, withdraw the case from the court, in which case the judge must immediately put an end to the proceeding and release the person who's the subject to the extradition request. It's not a question of interfering. The minister has the full control of this process from beginning to end, including during the entire period where, and that's where it gets a bit technical and it gets us into the SNC-Lavalin problem, the Minister of Justice instructs the Attorney General to represent the United States in court to clear up some of the legal issues. Now, the Minister of Justice and the Attorney General are the same person, but lawyers understand the different roles. This is not a criminal proceeding, has nothing to do with the government interfering. The Minister of Justice not only has the authority to control whether this case should continue to proceed, he has the responsibility. He can't even say, as I understand, is part of the argument, although nobody has addressed it directly, he has delegated his authority to the International Assistance Branch or Bureau of his ministry. It is his discretion, his responsibility, his authority to control this case from beginning to end. So to use the expression, it would be seen by the public as inappropriate for the government to interfere is a completely misuse of language. No question of interference, a question of exercising a responsibility that is vested in the Minister of Justice under the law.
Mr. Rock, the Minister of Justice has made the argument, though, and he has been very forthcoming in saying, okay, at the end of this, yes, once this plays out before the courts, I can very much intervene. Am I trying to get at, do you just dismiss that completely? Like, should he be getting up there and saying, actually, I could intervene right now, but I choose not to?
Yes. And then let's have a public discussion about whether he ought to or not, and have him explain his reasons why he won't intervene now. Let me put it this way. I was Minister of Justice for 4 years. We had many extradition proceedings come to my desk. There are two phases. There's the judicial phase, which we're in now, and if the judge decides that the evidentiary basis is met, it becomes a ministerial phase where the minister decides whether to actually surrender the person for extradition. So he does have a task to perform much later on. It could be 2 years from now by the time it comes to his desk and he gets his role in it. Why should we have the Canadian sitting in a Chinese prison for the next 2 years? That's really what this comes down to. Yes, he has a role later on, but he has a role now too. And what we're what we're pointing out, I'm too used to being a lawyer in these cases, but what we're pointing out, Vashi, is that the Extradition Act provides the minister with plain authority to act now, not wait for 2 years when it comes to his desk in the ministerial phase, but to act now. Take a step toward the liberation of the 2 Canadian hostages. And in all the circumstances of this case, we say he should. So that's what it comes down to.
Did you ever intervene prior to the outcome of an extradition case as Justice Minister?
No, I didn't ever have a case in the 4 years I held that portfolio, which had characteristics even like this one. I mean, they were very different. Nothing like the case of Madame Meng, with the factors we see here that make it so exceptional.
Okay, but what about, I guess, again, on the like, if the courts are saying right now that, and I just want to follow up quickly with you, Mr. Rock, if the courts are saying right now, if the BC court said that the double criminality does apply here, again, does that lessen your argument? If the courts are saying this should proceed here?
No. Well, what the judge was asked was to bring the proceeding to an end because there was a technical flaw in the case being presented on behalf of the U.S. The judge says there is no technical flaw, so it's going to proceed. What we're saying is the case should be brought to an end, not because of a technical flaw, but because the minister has the overriding authority to bring it to an end at this stage, and he should do that based not on a technicality, but on the national interests of Canada as a sovereign state, because what this case is doing to 2 of our nationals, what it's doing to our foreign policy, is unacceptable, and so it should be brought to an end. So the mere fact that the judge allowed it to proceed and said that technicality doesn't exist doesn't address the minister's overriding authority to end it for broader reasons.
Ms. Arbour, I know that you've laid out your argument to this very much so, but what kind of message do you think that would send China?
I think this is one of the considerations that would have to be examined in making the decision, in the minister making the decision. This is not about messaging, it's about making a decision, but the collateral effects might be sending signals to China, to the United States, to the rest of the world, to the Canadian public, to the 2 Michaels families. There's a series of considerations. And I think we have not had the opportunity of a full debate on that particular issue. In my view, at the end, it would send a signal that Canada is a country that has a sophisticated understanding of its rule of law environment, that an extradition proceeding is not the same as a criminal proceeding. I think the Canadian public would be very supportive. There's no question that there's not a perfect outcome. Somebody will be unhappy one way or the other. But I think when you inject the lives of 2 Canadians, and I say the lives with great seriousness, it seems to me that it certainly tips the balance in a case that, in my view, should not have proceeded in the first place because it was not aligned with Canadian national interest right from the outset. But tipping the balance, it seems to me, is very much that the life and safety of 2 Canadians abroad.
Okay, unfortunately, I'm out of time, but I thank you both very much for your time this evening. Thanks to Alan Rock, former Minister of Justice, and Louise Arbour, former Supreme Court Justice. Appreciate your time.
Thank you.
Pleasure.
Welcome back to Power and Politics. We've been talking tonight about whether or not Canada's Justice Minister could act to release Huawei executive Meng Wanzhou from the hearings into her U.S. extradition case. That's what the family of Michael Kovrig, one of 2 Canadians detained in China for more than 560 days, are calling on Ottawa to consider. We heard the case for doing so from former Justice Minister Alan Rock and former Supreme Court Justice Louise Arbour minutes ago. Let's get the government's reaction. Marco Mendocino is the Minister of Immigration, Refugees and Citizenship. He joins us from Toronto. Hi, Minister Mendocino. Good to see you again.
Hi, Vashi.
Minister, I have a bunch of questions that are very specific to your file, but I actually want to start off on a subject that you and I have talked about on this program before, and that is whether or not your government is going to intervene in a judicial matter. I'm not talking about SNC this time. I want to ask you about China. I'm sure you're familiar. Over the last 24 hours, Louise Arbour, Alan Rock, and the wife of Michael Kovrig have put forward the suggestion that your government should be entertaining at least the option of intervening or getting involved in the case of Miss Meng in order to try and advance the efforts to see Michael Kovrig and Michael Spavor released. What is your response to that?
Well, my response is to call on China to release the two Michaels. They continue to be arbitrarily detained. And this latest development where China has laid charges is another example of how they're continuing to politicize the process. By contrast, here in Canada, we believe in the rule of law. Ms. Meng is before the courts right now. This is an independent judicial proceeding. We are not going to intervene in that proceeding. Should the court choose to commit Ms. Meng, at that point the government will have a decision, but not before then.
I guess what I'm getting from my discussions with people involved in this is, why has your government chosen to, at this juncture, delegitimize the idea of intervening at all? I know that Minister Lametti, for example, and you before have said, at the end of all of this, once the court proceedings play out, yes, there is a role for the minister, and at that point, that decision is one that we could take. But the legal opinion put forth is that because extradition isn't a criminal matter, that it isn't a matter of national interest, this could be a role for the Minister of Justice. And I'm not saying that there isn't valid arguments against doing so, but why isn't it even in the realm of consideration for your government?
Because we believe in the different branches of government. And as I have said before, we believe that this is a process that must be independent, that is being carefully considered by the courts. And Vashi, as I've told you before, I'm familiar with this process. It's an intricate process. It's a complex process that is being undertaken by the parties before the courts. At that point, the point at which the court will take a decision, perhaps it will come to the government, but we do not want to preempt that.
From a legal perspective, you're a longtime prosecutor prior to getting into politics. Do you disagree with the legal opinion put forth, the one supported by Ms. Arbour and Mr. Rock, for example, that the federal government can intervene, that the Minister of Justice, rather, can intervene during the court proceeding at any time, not just after it's completed?
I believe that it's precarious to entertain hypotheticals and the kind of commentary, which of course is designed to spark additional discussion and dialogue about a proceeding that has been the subject of intense public scrutiny. We have an open court principle. You're reporting on it, Vashi, others are reporting on it. But what's absolutely paramount is that we in government, and particularly elected officials, and those who are charged with the responsibility of a secondary stage which is not yet reached yet, must respect the integrity and the independence of that process until it is concluded.
I don't really understand, though. Does that mean that you think fundamentally that legal opinion is wrong?
I'm saying that it would be inappropriate for me as a minister of the Crown who is sitting in government to be commenting about the opinions of others. What's important is that your viewers understand that I and my colleagues in government respect the independence of this process. That is a value that has served our democracy well. It is a pillar on which we will continue to uphold the confidence in the administration of justice, and that is a paramount priority for us.
Do you understand, I guess, the frustration and the sense of just desperation that Mr. Kovrig's family must feel, right? Like the fact that they've been there for more than 560 days. And I know that your government and you have talked about that, but they feel like they sent this legal opinion on May 22nd and they haven't heard a word back.
Of course, I understand that the frustration. That is why the Prime Minister and others have persistently called for the release of these two Canadians who are being arbitrarily detained, deprived of consular support, and other supports, including contact with their family. That's what delegitimizes the relationship between our two countries. That's what delegitimizes and frankly dehumanizes these two Canadian citizens, and that's why we will continue to call for their release.
Okay, let me move on and ask you about something that's happened south of the border that I wanted to get your interpretation of, and as well what it possibly means for Canada. And that is the White House administration, the U.S. Work visa ban. It's been extended now to the end of the year, and that was an announcement made this week. What does that mean for Canadians who have applied or are planning to apply?
Well, we're aware of the developments in the United States, Vashi, and we want to be sure that we can support any of them that have been impacted. But in Canada, I want to be clear. We believe that immigration is going to drive our economic recovery, and there are a few reasons for this. We have an aging workforce. We have more people who are retiring faster than ever. And if we care about maintaining healthcare and education and our long-term retirement covenants, we
好的，那我们就这个新闻先听到这里啊，因为下面的就无关这个孟晚舟的事件了。OK 那么现在呢，听完这一段新闻之后呢，我希望大家一起讨论也好，或者测试一下大家的听力水平也好。那么希望大家可以积极踊跃的在下面的 comment 这个讨论区做一下几个问题的讨论。首先呢是这个加拿大的司法界人士就是那个Mr. Rock 和那个Louise， 他们两个呢是代表了这个加拿大的，一个是前任的这个司法部长一个是前任的他的这个最高法院的这个法官。那么他们呢是联署了其他的一些重量级的加拿大的政界和司法界人士提出了什么样的一些论据来支持这个提早结束这个引渡案还有就是释放这个孟晚舟。然后呢就是在后一部分的时候呢主持人所采访的一个加拿大的一个移民部的部长其中作为所谓的政府代表还有这个主持人本身他们又提出了什么样的论据来反对这个政府或者加拿大的司法部这个提前介入结束这个引渡案他们又提出了什么样，就正反两方吧，相当于他们提出了什么样的一些论据。然后呢你们是听到了，当你们可以反复去听这一则新闻，你们听到了什么对于你们来说觉得非常实用高频常用的一些英语的词汇和词组可以在下面的讨论区跟大家一起分享一下。那这个是这一期因为太长了，我们就分成2期。下一期呢我会就做这些刚才的一些问题，跟大家一起来共同讨论所涉及到的，首先这一个政治事件，然后他们的一些论据然后当然是会一起来学习一下一些常用的英文的词汇和词组这是上一部分还有另外一部分刚刚今天才出来的就对于这件事情的另外的一些讨论一些进展那个我会有做下一期来专门作为给大家的这个解答。好，那么再提醒一下，喜欢我们的朋友别忘了点击右下角的这个订阅键订阅 subscribe 我们的频道然后这个点赞分享，还有开启这个下期节目提醒的小铃铛。好，谢谢大家的收看，再见。